The Centre for Public Legal Education Alberta, CPLE, is a non-profit organization with the goal of making the law understandable for Albertans. CPLE provides legal information and education to the public. Only lawyers can provide legal advice. Look for our contact information at the end of this video. Enjoy!
The Centre for Public Legal Education Alberta runs a residential tenancies legal information program, which provides legal information for landlords and tenants in Alberta. The program is funded by the Alberta Real Estate Foundation and has been going strong since 2000. You may be familiar with our Laws for Landlords and Tenants in Alberta website. We get many questions every year about renting, from both tenants and landlords throughout Alberta. We also keep track of popular search terms on our website, so we have a good idea of the types of issues or questions that tenants and landlords deal with frequently. This video is part 1 of a compilation of our top 10 housing law issues. We will discuss the Residential Tenancies Act, rental applications, and the different types of leases in Alberta. First off, to provide some context, let's talk about renting law. In Canada, each province has a different law that deals with renting a home. The law in Alberta is different from the laws in other provinces. In Alberta, the Residential Tenancies Act, or the RTA, outlines the rights and responsibilities of most landlords and renters in Alberta. The RTA sets minimum standards of conduct for both landlords and tenants. Under the RTA, the landlord has a number of responsibilities. For example, provide a signed copy of the lease within 21 days, give contact information to tenants, provide inspection reports within 7 days of the tenant moving in and out, do not disturb the tenant's right to peaceful enjoyment of the property, meet minimum housing and health standards, give valid reason to end a periodic tenancy, and follow rent increase rules. If the landlord does not fulfill these responsibilities, they could be fined by Service Alberta and/or face court action by tenants. Likewise, the RTA lists 7 covenants or rules that tenants must follow. They are: pay rent in full and on time, do not interfere with the rights of the landlord or other tenants, do not commit illegal activities in the rental property, do not endanger or threaten other people or property, do not cause significant property damage, keep the property reasonably clean, move out when the tenancy is over. If a tenant does not follow any of these rules, they could be evicted by the landlord. Now that we have some context on the RTA, let's start diving into the first housing law issue: rental applications. When a tenant is filling out a rental application, the landlord asks for proof of income, who and how many people will be living with them, and landlord references. So can the landlord ask for this type of information? Well, in short, the answer is yes. Landlords can collect information necessary to make a decision about whether or not to rent their property to the applicant. This may include proof that the tenant is capable of paying rent, such as proof of income. So for example, a pay stub or an income tax statement. If a tenant cannot or does not want to provide proof of income, the landlord can refuse to rent to the tenant. A landlord can also refuse to rent to a tenant if a tenant has bad references from previous landlords. So for instance, if an old landlord indicates that rent was constantly paid late or damage was caused to the unit, a landlord can refuse to rent. There is a caveat with landlord references though. If a tenant does not have any previous references because they're new to renting or perhaps new to Canada, then the landlord should not refuse to rent on that basis. How about other pieces of information? What if a landlord asks for information like social insurance number, SIN, credit checks, or criminal records? Asking for this type of information from a tenant is not as straightforward. For SIN, the landlord must have a legitimate purpose for requesting the SIN and explain that purpose to the tenant. Normally, a SIN is not considered necessary information required by the landlord. Sometimes a landlord will request a SIN to do a credit check, but credit checks don't require a SIN. A tenant's full name and birth date will do. Plus, a tenant can offer their own credit report. If a tenant feels uncomfortable disclosing their SIN on a document, then the tenant can block this information out. As for credit checks, landlords must have a reasonable purpose for doing so and explain that purpose to the tenant. If the landlord has concerns about non-payment of rent and must verify an applicant's credit history, this may be reasonable. But before ordering the credit report, landlords are required to obtain the tenant's consent. When it comes to asking for a criminal record, the answer is no. A landlord cannot, as a condition of renting or providing any service to a tenant, ask for consent to collect personal information beyond what is necessary to provide tenancy or that service. To summarize, landlords can collect information necessary to make a decision about renting their property. But information collected by the landlord is covered by the Personal Information Protection Act. For more information, you can refer to Alberta's Information and Privacy Commissioner's website and their publication, Privacy and Landlord Tenancy Matters FAQs Tip Sheet. The next issue is an issue that we get questions about all the time: different rules for different leases. So for example, a tenant has a fixed term lease. They recently found a new job in another city and will need to move. They want to break the lease early. So is the tenant responsible for paying rent until the lease ends? Well, when signing a fixed term lease, the tenant agrees to pay rent until the end of the lease. A tenant cannot end a fixed term lease early unless the landlord gives them permission. If a tenant leaves early without the landlord's permission, the tenant is responsible for paying rent until the lease ends or until the landlord is able to rent the unit again. Since we're talking about leases, let's back up a bit and talk about what a lease actually is. A lease is a written agreement or the contract between the landlord and the tenant. It will outline what the landlord is responsible for and what the tenant is responsible for. Verbal leases are legal, but not recommended because it's hard to prove what the lease terms were if a dispute arises. If the landlord or tenant does not live up to the promises they made in the lease, there are certain things that can happen. So for instance, a landlord could evict a tenant if they do not pay the rent when it is due. Another important thing to keep in mind is that the rules in the Residential Tenancies Act automatically become part of the lease, whether they are explicitly written into the lease or not. A landlord cannot change anything that protects the tenant in the Residential Tenancies Act. So for example, if the lease says the landlord can't enter a tenant's apartment without notice to make repairs, then this would be wrong because the law says the landlord must provide 24 hours notice to enter. It is important to understand that there are two types of leases, as the RTA assigns different rules depending on whether a lease is fixed term or periodic. A periodic lease is often called a month-to-month lease. It may also be week-to-week and sometimes year-to-year. This kind of lease keeps on going until the tenant or landlord does something to end it. A fixed-term lease begins on a specific day and ends on a specific day. These dates will be written in the lease. So why is it important to know the difference between periodic and fixed-term leases? Well, different rules apply to different kinds of leases under the Residential Tenancies Act. So for example, when a landlord can end a lease, when a tenant can end a lease, and also when it comes to rent increase notices. So let's get into some details to highlight the differences between periodic and fixed-term leases. Let's first look at when a landlord can end a lease. To end a periodic lease, the landlord must 1. Have an allowable reason under the RTA. For example, the landlord moving in, the property is sold and a new owner ends the lease, major repairs, and 2, provide written notice. So the amount of notice that a landlord must give a tenant to end a tenancy depends on the type of periodic tenancy, except for termination for major renovations, condominium conversions, and employment. On the other hand, to end a fixed term lease, the landlord can only end the lease early with the tenant's consent. Let's look at when a tenant can end a lease. To end a periodic lease, the tenant must give notice 1 tenancy month in advance, if the lease is a monthly periodic lease, or 1 tenancy week in advance, if the lease is a weekly periodic lease. On the other hand, to end a fixed term lease, the tenant can only end early with the landlord's consent. The tenant can talk to the landlord and make an arrangement in writing to end it early. Alternatively, they can try to sublet or assign the unit to another tenant. Landlords in this situation are obligated to mitigate their damages by trying to find another tenant as soon as possible. Now let's look at the rules when it comes to rent increases. So for both periodic and fixed term leases, rent can only be increased after 365 days have passed from when the tenant moved in or since the last rent increase. There is also no specified limit on the amount of increase. But for increases with periodic leases, the landlord must give 3 tenancy months notice, whereas for rent increases with fixed term leases, a landlord does not have to give notice of rent increase. Domestic violence is one special circumstance where a tenant can end their lease early. In August 2016, changes to the RTA were made, giving tenants who are experiencing domestic violence a way to end a lease early without financial penalty. The tenant can apply to end a lease if they are named in the lease and their safety or the safety of a dependent is at risk. A dependent can be a child or a protected adult, which means an adult who has another person make decisions with or for them according to a court order under the Adult Guardianship and Trusteeship Act. CPLE has created a tip sheet called Renting and Domestic Violence, Ending Your Lease Early, which explains this process in further detail. Don't forget to check out our Laws for Landlords and Tenants in Alberta website. To access all of our publications about renting in Alberta, you can download them for free on our website, or you can contact us to get a printed copy.
Thank you for watching this video from the Centre for Public Legal Education, Alberta. We endeavour to make the law understandable for Albertans. You can find CPLE's resources on our website, cple.ca, or reach us via email at info@cple.ca, or simply by phone at 780-451-8764. Until next time.